Welcome to the Jet Setters and the High Rollers, to the Shot Takers and the Tastemakers. Welcome to the Viewfinders, the Thrill Seekers, and the Night Owls. Welcome to everything you could possibly want on one 5-mile island. Welcome to the Wildwoods. Book your stay today.
Hi, ladies and gentlemen around the Delaware Valley. Welcome to the Jeff Gross Show here on WWDB Talk 860. We've got a fantastic broadcast. Today we're talking workers' compensation with one of the region's premier workers' compensation attorneys. And, one of the things about workers' compensation is it is a specialty of law that I can tell you that dabbling is not an option. So you will not find lawyers walking and doing law at the wills and estates who do workers' compensation. It's one of the most specialized areas of the law. I'm ecstatic to bring into the program Jeff Gross. How are you, sir?
Good, Joe. How are you today?
I am fantastic, sir. And if you would, introduce yourself, tell our listeners a little bit about yourself, and then the firm, of course.
Of course. My name is Jeffrey Gross. I've been handling workers' compensation claims on behalf of injured workers against employers and insurance companies. I never represent employers or insurance companies for the past 35 years. I handle all kinds of work-related injury claims, including catastrophic losses from falls, motor vehicle accidents, injuries from lifting, repetitive stress injuries, occupational disease claims, you name it. If you're injured at work, it's within my gambit, and I handle that kind of a claim. My firm is Gross and Kenny LLP. We're in downtown Philadelphia, in Center City, and we represent individuals all across the state, and we do represent injured individuals in New Jersey as well from work-related injuries. When I say all over the state, I mean we go all over the state. We've handled cases in Erie, in Pittsburgh, in Scranton, in Harrisburg. So the entire state is within our purview, and our niche is Philadelphia, though. That is our strong point.
So, Jeff, it's an interesting area of the law. One of the things that people should understand is work injuries, okay, and personal injuries, although there is overlap. So when I say personal injury, I'm talking about a car accident or a slip and fall. A work injury is completely different in the eyes of the law, although there are third-party cases, which we'll get into. And one of the things I talked about at the beginning, and you and I know a lot of really good personal injury attorneys, but I can tell you, and I know you know this, we've talked to the best, and they've said to us directly, that, the one guy we're thinking of who said to us, I dabbled in workers' comp for 2 weeks and got the hell out of that because it's such a specialized area of the law. So when we say no dabbling, okay, obviously that means you got to do it full time. And Jeff, talk about why that's so important.
It's really important that if you are not fully immersed in the field of workers' compensation, that you stay away from it, because it is not something that is easily grasped. And when I say that, I mean there are all kinds of nuances, pitfalls, labyrinths, mazes, however you want to look at it, that are very difficult to manage. You're not just managing a code, which is the statute of workers' compensation. You have to know how that code applies to existing case law and to different factual situations. You also have to know all the players in the field, because otherwise you will be at a disadvantage. So we know all the judges involved. I know all the judges statewide. I know the players that are involved for both my side as well as my opposition, especially my opposition, I know, because I deal with them on a daily basis. So it's important to know all of the people involved and all of the elements involved so that you can be effective for your client. And that's basically what I have done. I've decided back in 1991 that I would do this as my niche. and I concentrated in handling workers' compensation from the get-go because it's a big passion of mine for reasons I can explain if you'd like. But it's a real passion of mine to be able to represent an injured worker as a result of a work-related injury, because I do have that knowledge base and I do use that to help my clients to the best of their interests.
And so I do want you to go into that because it's a very interesting story. But I want to clarify when I mentioned personal injury and workers' compensation, work injury, personal injury, and of course
Yes.
I gave some examples. But what is the basic uh, difference between somebody who gets injured in a car accident, they suffer that injury, and somebody that suffers an injury that happens in while they're at work?
So the main difference is the fact that it occurred at work or in the course and scope of one's employment. You have to be in the course and scope of your employment to have a workers' compensation claim. The difference is that if you are in the course and scope of your employment and you suffer a work-related injury, you're entitled to basically two things. You're entitled to wage loss benefits, usually at the rate of 2/3 of your gross average weekly wage, which, by the way, is a term of art because that can have lots of exceptions and varies depending on the amount of money you're making. And that is payable to you for the duration of your disability. It starts from the date of your injury and is ongoing indefinitely until you are either able to return to work or make a settlement or fully recover. But mostly making a settlement or returning to work is what stops it. You're also entitled to the second aspect of the claim, which would be medical benefits. There are no copays, there are no deductibles in workers' compensation. You do not have to pay for any medical expenses, including prescriptions or anything else. And if you are paying out of pocket for those things, I want to make sure that you're reimbursed for whatever you've spent out of your pocket for your treatment. Essentially, the law covers any injury and the treatment for that injury until you no longer need it. And basically that is payable at the rate of 113% of what Medicare would pay for your treatment. Any additional amount has to be written off by the medical provider. So at no time is the injured worker responsible for any medical treatment at all.
So
And
what
the
I
difference, just to finish your good question, the difference between the work injury and the non-work injury is basically one of the economic nature of this. So workers' compensation will cover the economic losses that you sustain as a result of the work injury. Economic losses basically means your out of pocket uh, expenses or expenses that I can readily calculate as a result of this accident. For instance, I can calculate your wage loss benefits, both past and present, and as well as extrapolation into the future. I can determine what your future wage loss might be. I can calculate your medical bills. I can also calculate your future medical bills based on your needs for medical treatment moving into the future and give an estimate for that. That's all covered by the workers' compensation statute. What's not covered is your non-economic damages. Non-economic damages are damages that I cannot readily calculate. For instance, I cannot calculate your pain, your suffering, your loss of life's pleasures, your mental anguish, your humiliation, your embarrassment, all kinds of things like that. And I could give you a laundry list of non-economic damages that are not calculable. The difference is those kinds of damages are recoverable in a third party claim. When you talked about that earlier, third party claim, what you're referring to is when I say that you say the number three, third party, it's not the number three, it means other in the law. So when you hear of a third party claim, you mean you're suing somebody other than your workers' compensation carrier or your employer. You cannot sue your employer or the workers' compensation carrier for negligence. If they put you in harm's way or they caused an accident, there's not much you can do other than the workers' compensation claim. But if someone else besides your employer created a situation, either by negligence or otherwise, that caused your injury, you can sue that entity and you can make a workers' compensation claim. The pain and suffering or non-economic damage component would be had by making that third-party claim. And we work together with various third-party attorneys to maximize your recovery. So you have dual experts, me as the expert for workers' compensation, and another attorney who we are familiar with and who we work with on a daily basis to get you the maximization of your third-party claim.
And so when you talk about third party personal injury workers' comp's a no fault statute, correct? In other words, if I'm working
Correct.
the job and I have a beater, I'm working as an iron worker, and the beater slips, and I hit myself in the foot, okay, and I break my foot, I'm still eligible for workers' compensation. But when it comes to third party or personal injury claims, there's always a negligence part of that. Negligence is not a part necessarily, doesn't have to be a part of workers' comp, if you will.
For instance, so yeah, exactly. So if I am driving a delivery truck and I get struck from behind, I can sue the driver of the truck that struck me and the company that that driver was working for, or even if it's an individual, I can go after that individual and still make the workers' compensation claim against my employer because I was in the course and scope of my employment when the accident happened. But I have another claim against that other driver. As far as negligence is concerned, if I'm driving and I fall asleep at the wheel and I strike a tree, yeah, I'm not going to be able to sue anybody because I'm the one that caused the accident. However, I can still make that workers' compensation claim because it's a no fault basis claim. Workers' compensation, it doesn't matter whose fault it was, they still will cover you.
And so when we look at that type of a situation, okay, and you mentioned your employer, workers' compensation, in a sense, you're you're really filing a claim to on your workers' compensation carrier. You're not, in essence, like when it's a third party case and it's a personal injury, you are suing. Okay, you are going after that third party, that negligent party that created the accident. However, when it comes to workers' comp, you're actually filing a claim against your workers' comp insurance.
Correct. So when you look and search for any individual that's made a workers' compensation claim, you're not going to find anything in the court documents in the Court of Common Pleas of any of the counties in Pennsylvania. They would be limited to a WCAIS, WCAIS, which is the Workers' Compensation Automated Integration System, and that is the site that you would obtain all of the claims for workers' compensation. You're not filing a lawsuit per se against your employer. You're making a workers' compensation claim, and all employers in Pennsylvania must be insured. You have to have workers' compensation coverage for your employees. To the extent that you don't, that is actually considered a class 3 felony. And so you need to have, there has to be workers' compensation coverage in any employment situation. If there's not, there is a fund called the Uninsured Employer Guarantee Fund that covers you for that. But anytime you're making a workers' compensation claim, you're doing so through a filing of a claim petition through the state, and it's an administrative law claim. It's not a lawsuit like you would file against another individual or another entity.
So let's talk about what your requirements are under the law in regards to being injured on the job. If you get injured on the job, what are the first requirements that you have to do?
The absolute first thing you need to do once you realize you've been injured at work is to notify your supervisor, someone who is more supervisory to you in your line of employment, whether it be a direct supervisor, whether it be HR, whether it be a person who is above your supervisor because your supervisor is not available. Notifying a coworker in and of itself may not do the trick. So you need to find someone supervisory to your role and notify that person. And that rule is a 120-day rule. You must notify them within 120 days. Although I will tell you, if you wait 120 days, that's no good. you will lose your credibility for your claim. You need to do it immediately. So as soon as you're aware of a work-related injury that you've had, you should immediately notify your supervisor. Here's the pitfalls. Many people are unaware that they have to do that, number one. But if you are aware that you have to do that, many people are reluctant to do it because they're afraid of getting in trouble. They're afraid of losing their job. They're afraid of all kinds of issues. Suffice it to say, if you don't take care of yourself and protect yourself by notifying your supervisor of the work-related injury, you're going to be left out in the cold. It's better safe than sorry to notify your supervisor. And by the way, many people who don't notify their supervisors about these injuries and then later do so are then looked upon in a very negative manner and many times are terminated down the road because of that reason, although the employer may not even tell you that because they don't want you to know why they're terminating you. In Pennsylvania, you could be hired or fired for any reason or no reason at all unless you have an employment contract and unless your rights are not you're not discriminated against. So you have to be very careful and you must notify your supervisor. That's the number one thing.
And when you talk about notifying, uh, in which way, which manner is that? Is there a preferable way to?
It's always preferable to do it in writing. And when I say that, I don't mean you have to compose a letter to your supervisor. You can text your supervisor. You can call your supervisor. You can email your supervisor. It's always best to have it in writing only because you'll have proof of it. But it doesn't have to be that way. Oral notice is perfectly fine. It's just that you need to follow up with something that shows that you notified them. So if you gave them an out of work note or a medical excuse note of some kind from a doctor or hospital, you want to send that to your supervisor by email or text or delivery personally, so that they have something that's in writing.
And you mentioned somebody's afraid. A lot of people are afraid of being fired, and like you said, uh, yeah, it's not always quite that simple. Employees are pretty employers can be savvy, but legally speaking, can you be fired for, um, for filing a workers' compensation claim?
If the reason that they're firing you and they tell you this is because you're filing a workers' compensation claim, that is illegal. Okay. There's plenty of case law out there that shows that kind of retaliation by the employer is not kosher. Okay. What they can do is they can terminate you and blame it on something else. Yeah, we're downsizing, we can't keep you, or we needed to fill your role and you're not coming back, and we for economic reasons we have to let you go, or for administrative reasons we need to let you go, having nothing to do with the fact that you're making a workers' compensation claim. But if they actually come out and tell you that, that would be illegal.
And how often, especially and long time employees, but really just in general, how often when somebody walks in your office, is the first thing they say, "I'm afraid to get fired. Can I get terminated?" And then, if you will, because these employers and workers' comp insurance companies do the craziest things to people,
They
particularly
do.
those individuals that try to represent themselves. So, if you will, talk about this, but then I'd like you to get into why you chose workers' comp. Here's a great
Okay.
example of why people need representation.
So just to answer your question, many people who come see me are afraid of losing their jobs. They tell me when they come in, I don't know what's going on. I'm really in bad shape, but I got to get back to work. I don't want to get fired. And the truth is that it would be a mistake for an employer to fire an individual or an injured worker because all that does is make them lose control over the claim. Let me explain. If you get hurt at work and you can't work and do your job, and the insurance company is trying to limit its exposure for what they have to pay to you or limit the claim as far as value for settlement is concerned, they're going to want to do everything they can to get the employer to hire you back in a modified or light duty role. And the reason is because once they bring you back into that modified or light duty role, they don't have to pay you workers' compensation. So if you have a job where it's a heavy labor job and you're being offered the same rate of pay, the same exact benefits, and all you have to do is come in at 9 and leave at 5, you get a half hour for lunch. it's a no-brainer for them. They should do that because that will cause your workers' compensation benefits to stop, and that's considered legitimate by the Pennsylvania Supreme Court. And that was done a while ago. This is long-standing case law. But if they were to terminate you while this was going on, they can't offer you that modified or light duty job at that point because you've already been terminated. And what ends up happening is that the value of the case will go up if they terminate you. Why? Because then they can't control you. They can't bring you back and reduce the value of the claim. They can't bring you back and stop the workers' compensation benefits because they've terminated your employment. So it's a red herring, this termination of employment. But I assure people that when they meet with me, they have basically three options. Option number one, to go back to work as quickly as possible. Option number two, to stay on workers' compensation until they're at a point where they feel that they're capable of returning to work. And option number three, stay out of work, handle the case so that they improve to the best of their ability to their maximum medical improvement level. And if they're still unable to return to work, then we get them a settlement and we maximize the value of that settlement.
Okay, so so many people, especially in the union world, but across the world, across the land, want to try to navigate these situations themselves. And you know, even if somebody is close with their employer, okay, and I've heard stories, and you can talk on this, where the employer themselves saw the injury and reported it to the workers' compensation provider, and still they were denied. Okay, so
Happens all the time.
yeah, and so it's such a why does that happen so often? Um, the employer is required to buy workers' compensation insurance. Okay, certainly, you know, the injured worker is in a situation where they may have been working loyally and hard for years. Okay, they're covered, and yet uh, it's a regular basis. On a regular basis, individuals get intimidated, that they get their benefits denied, and all those things. Uh, this may sound like and people always think, well, they'll be loyal to me because I've been loyal to them. Uh, talk
The
about.
reality, yeah,
uh,
the reality is that these employers, they can be loyal to you, but it has nothing to do necessarily with the employer. They can call in the claim. They can report everything that is required of their duties to report to the carrier. And then the workers' compensation carrier can review everything and make an independent decision that there's no claim that's benefit here. That's a viable claim here. And they could deny your claim, even if the employer is supportive. So it's not necessarily the supporting mechanism of the employer that's going to drive the claim. It's really convincing the workers' compensation insurance company. And that's something that we do. We checkmate the insurance companies. We make sure that there is no way that if you are disabled from a work-related injury, we're going to make sure there's no way that they can deny the claim. If you have objective findings, a herniated disc, a fractured bone, a displaced comminuted fracture, a closed head injury where you have lost consciousness, if there are situations where you are really injured and disabled from your job, there's nothing that can stop us from making and succeeding in a workers' compensation claim on your behalf.
And Jeff, how soon should somebody consult legal counsel? Is it confidential? Okay, and why is it so important?
You want to get an attorney as soon as possible, you at least for a consult, so you know what you're doing. It's not for everyone. These claims are not for everyone. They're for people who get hurt at work and who are unable to do their jobs. Essentially, you need a lawyer. So I would say immediately is when you need a lawyer. And the answer to your question is yes, it is confidential. Attorney-client privilege is extremely first of all, it's all confidential, and it is a legal tenet that you cannot breach the attorney-client privilege as an attorney. I can't go to the employer and say, hey, listen, this guy's thinking of making a claim against you. That's not how it works. The way that it works is you tell me through an interview that I would interview you You tell me what I need to know, and then you can tell me all your secrets. They're safe within this head. It doesn't go anywhere else. And then I do what's in your best interest to help you achieve what your desires are or what your best interests are.
So we're talking about workers' compensation and the point of injury on this broadcast. You only have a couple minutes left, but I do want to ask Jeff about medical treatment. Okay, when you get injured, uh, where can you go? Can you go to an emergency room? And then uh, where do you have to go after that? We only have a couple minutes.
All right. So initially, when you get hurt, and I told you have to notify your supervisor, you're going to ask the question, where can I go for treatment? And if they give you, first of all, they have to give you a list of panel physicians in order to captivate your treatment to those doctors. If they don't have a list and you've not signed an acknowledgement that says that you understand that there is a list of panel physicians, and they have to provide up to 6 of these so that you have an option. But if they don't give you that list, you can go anywhere you want. If they do give you the list, but you haven't signed an acknowledgement, both at the time that you were hired and then again when you got hurt, then they still can't make you go to their doctor. They may deny the claim and you might have to fight them uh, with some litigation, but ultimately you should prevail again if you're serious, your claim is serious enough.
Jeff, at that point, you also have a network of medical providers that you can refer them to that will
I do.
Oh, fantastic. Jeff, if somebody wants to get in touch with you, how would they do that?
They would call me basically on my cell phone. That's the best place to get me. I give all my clients and any prospective clients my cell number, which is 215-512-1500. Or you can also email me at jgross@gk-wcl.com. Or you can go to my website, which is www.philaworkerscomp.com.
All right. I want to thank everybody for tuning in to the Jeff Gross Show here on WWDB Talk 860. I want to thank our host, Jeff Gross, for a fantastic education about workers' compensation in Pennsylvania. By the way, this is segment one of a number of segments that are going to be available on Apple TV, Roku TV, and Fire TV via the NetStream app. On behalf of Jeff Gross, I'm Joe Doherty. Thanks for listening, everybody.
Welcome to the Jet Setters and the High Rollers, to the Shot Takers and the Tastemakers. Welcome to the Viewfinders, the Thrill Seekers, and the Night Owls. Welcome to everything you could possibly want on one 5-mile island. Welcome to the Wildwoods. Book your stay today.